Okay, welcome everybody. I'd like to welcome everybody here today. This is today's session is being sponsored and put on by the Animal Control Advisory Task Force, which I chair. And so we're very fortunate to have Jake Kamens here. He works with the Benton County DA's office, and he's the nation's first dedicated full-time animal cruelty prosecutor. He's also works with the district attorney's offices in 21 of the 36 counties in Oregon, and he has prosecuted and helped prosecute several animal cruelty cases. And today we're going to be learning a little bit more about how to process and get evidence for investigations, and learn a little bit more about techniques and things that will help us out. So let's welcome Jake.
Thank you, Doug, and thank you all for coming and for having an interest in this very important topic. I'm going to cover a lot of information. I do not mind stopping for questions. If you can't hear me or you need something repeated or reiterated, please let me know. I know we've got, I took a look at the sign-in sheet. We've got people from a variety of different disciplines here today. So therefore, some of you will know some of this information, and some of you will know other of this information. I'm not trying to talk down to anybody, but it's really important that when you're dealing with these animal cases, because you have a lot of people coming in from different disciplines to work on the cases, that everybody have a basis for understanding where everybody else is coming from. So I always start with introducing myself and talking a little bit about the position. I have been an animal cruelty deputy district attorney since September of 2013. When my position was created, it was created with an agreement between the Oregon District Attorneys Association, which is like the trade organization for all the DAs in Oregon, and the Animal Legal Defense Fund, which for decades has assisted prosecutors throughout the country and really throughout the world prosecuting these cases. The reasons, for anybody who's worked on one of these cases would be obvious. They are time-consuming. They are resource-consuming. They are complicated. They often have dozens or hundreds of victims at a time. And people have very high emotions. These are cases that often end up in the media just because the victims are these poor defenseless animals. So they're cases that the Animal Legal Defense Fund has been helping with for years, and they decided it was time to sort of center their resources and see if they could make a difference by providing one prosecutor, one subject matter expert, in the same way that the State Department of Justice may have a subject matter expert in DUII or a domestic violence specialty prosecutor, something like that. So since the position was created, other states have joined in this fight. I know my home state of Virginia has a whole unit in their Department of Justice dealing with animal cruelty cases. So I'm no longer the only statewide animal cruelty prosecutor. My home office is Benton County, and all that means is that any kind of correspondence flows through there, because living in Portland, I'm not driving down to Corvallis on a day-to-day basis. I do handle all their animal cruelty cases, but I'm only down there when I'm dealing with a case there or doing something administrative with my job. So, but on a daily basis, I'll be in Dallas, or I've been in Grants Pass. I've gone to the coast on a number of different counties all over the state. So the important thing to know about my position is that my boss on any particular case is the district attorney who has sworn me in. So, for example, if I worked on a case here in Klamath County, Ms. Costello would be my boss. If I work on a case in Benton County, John Haroldson is my boss. So I never take any direction from the Animal Legal Defense Fund. I never take any direction from the Oregon District Attorneys Association. When I do this kind of work, it's at my own initiative and just in a spirit of helping train up the various communities on these issues. The main part of my work is the prosecution work. As Doug said, I've worked in 21 of Oregon's 36 counties. That's not to say that I couldn't work in those additional counties, but they are either too well funded to need my assistance, Washington County, Clackamas County, Multnomah County, or they don't have animal cases, or the animal cases that they have don't need specialty assistance. So I haven't covered, as you can see, a good swath of the eastern part of the state. I have been appointed officially on over 125 cases. I've also been working in terms of just assisting deputy district attorneys and law enforcement officers on cases in dozens and dozens of more cases. So very often I'll get calls, what do we do in this situation? And that's not necessarily a case that I'm going to get appointed on, but it's something that I can help out with based on my experience. The second major part of my job is what I'm doing right now, training. I've presented to groups of all different kinds, veterinary associations, animal rescue groups, law enforcement agencies, attorneys, people who want to be attorneys. I'm going to be teaching a class at Lewis and Clark Law School next semester. I'm very proud of that. Really just trying to bring light to these issues because, as you all probably know, animal cruelty cases don't come up as often in our system as, say, domestic violence cases or DUIs or drug cases. So when they do come up, very often the people involved in prosecuting them and investigating them may not have the most solid understanding of, emerging laws and trends in the law and case law in terms of how to best work these cases. So training is a really important part of my job. I'm proud to say that I've gotten to a lot of different parts of the state and trained a lot of different groups. The final part of my job, it's fairly minor, is just acting as kind of a media expert on these issues. So oftentimes if the Supreme Court or the Court of Appeals comes out with a case having to do with animals, they'll want a comment. What does this mean for animals in Oregon? What does this mean for people in Oregon? My favorite is, does this mean that animals are people in Oregon? And I always have to sort of take the position of, well, this is where the law has been interpreted, and this is what this means. And we'll talk a lot about those laws and those case laws, but the media just likes to put a face and a name next to some kind of official position. And I never represent anybody but myself in those circumstances, just as a person who's got some expertise in the area. So, I want to start at a basic level, and I know to some in the back this is going to sound a little bit elementary, but it's important that everybody's on the same page. So, I prosecute crimes. As an appointed deputy district attorney under one of the 36 elected DAs, I have the privilege of representing the state in criminal prosecutions. Now, what that means is that the state has decided that somebody needs to be charged for a criminal activity. And when we talk about that, the first thing we have to determine is, what is a crime? So crime has two parts to it, and I'll tell you why I'm talking about this specifically in a minute. Mens rea, which means your mental state. Did you mean to do it? Did you do it intentionally? Did you do something recklessly? Were you recklessly driving your car? Or did you do something with criminal negligence? And the reason that I bring that up is because we all know that somebody committed a crime when they picked up their gun and they shot down their enemy. That's obvious. It's an intentional crime. They consciously had the objective to cause the person's death. But then, when you get down into this criminal negligence definition, this is where animal neglect lives. And what it means is it means that the person committing the crime failed to be aware of a substantial and unjustifiable risk that their behavior would cause a certain result. So think about what that means for a minute. That doesn't mean they knew that they were committing a crime. That doesn't mean that they set out to commit a crime. That doesn't even mean that they recklessly committed a crime in terms of, they knew what the risk was and they did it anyway. That means they failed to be aware of what a reasonable person in their circumstance would be aware of. Because the number one excuse that I hear from people caught up in animal neglect cases is, I didn't know. And under Oregon's law, under these definitions, that's not a defense. Now, the other part of it is an act, a bad act. And in this case, it may be an act or an omission. Why that's important, specifically when we're talking about animal neglect, is, as we'll talk about in a minute, Oregon law requires you to do certain things for an animal in your custody or control. You have to provide that animal with minimum care. And if you don't, then that's what's against the law. That's the omission. And that's part of the guilty act of criminal negligence. Because the other thing that you'll hear from these folks that are committing animal neglect is, I didn't do anything. Well, that's kind of our point. You didn't do what you needed to do. So we have the sad cat with his empty bowl here. All the elements of a crime have to be proven beyond a reasonable doubt. And if you've ever served on jury duty, you've heard that phrase. If you've ever served on a criminal case. If you've ever served on a civil case, you've heard preponderance of the evidence, which means the burden of proof is just over 50%. You take a scale and you add a grain of rice on one side, and your case is proven. The burden of proof in a criminal case is beyond a reasonable doubt, which often is expressed in these terms. The jury, the fact finder in a criminal case has to have a moral certainty that the person is guilty, or they vote not guilty. So if you get frustrated, if law enforcement looks at your case and says, you know, this is bad, but we can't prove it. If the DA takes your case and says this is bad, but because the facts are just not there, understand that it's a heavy burden for the state to prove beyond a reasonable doubt. I want to do a quick overview of all the laws that we have, and then I'll dive down into them. Basically, when we're talking about animal cruelty, we separate it out into two categories: animal abuse and animal neglect. And I've listed out some of the various statutes there. Can be misdemeanors, can be felonies in both circumstances. You can have a neglect felony, you can have a neglect misdemeanor. And basically the difference is what I already talked about in terms of neglect. You don't give the animal what it needs for minimum care. Abuse is you're taking some kind of physical action that harms the animal, and you're not allowed to otherwise. All right. Animal abuse, causing physical injury, or causing serious physical injury, or cruelly causing the death of an animal. And this is intentionally, knowingly, or recklessly. This doesn't come into play with the criminal negligence statute. So for these crimes, you don't have to own the animal. It could be your neighbor's animal, it could be an animal that you've never seen before, it could be an animal that you're babysitting for, what have you. You don't have to have control or custody over an animal. You can abuse your own animal. And it's tough to prove, and these cases are tough to find and tough to work on, but it can happen. There's pretty specific legal definitions of what physical injury is and what serious physical injury is. Serious physical injury is a very high burden. When I'm reviewing a case, the only way that I'm going to charge somebody typically with serious physical injury is if they are permanently disfigured. The statute says protracted disfigurement, but there's case law that says that has to be a very significant amount of time. If they lose a limb, if they lose the ability to function, some kind of organ, like they lose an eye or something like that, it's a very high burden. And if you don't have serious physical injury, then you're stuck with physical injury, which on the plus side is a little bit more lenient of a standard than you have in the human crime world. So whereas an injury to a human may not rise to the level of physical injury where the human defendant could be charged with assault in the 4th degree, so you might be stuck with like a harassment charge or something like that. For animals, physical injury includes physical trauma, impairment of physical condition, or substantial pain. And those are a little bit easier to prove than the human physical injury definition. And then there's this issue of cruel death. I'll talk a little bit more about that in a minute. Aggravated animal abuse is a felony in Oregon, and it has to do with either maliciously killing an animal or torturing an animal. Aggravated animal abuse is also the only statute which veterinarians under Oregon law have a legal duty to report if they suspect that it happened. So they have a legal duty to report aggravated animal abuse to law enforcement. They are protected from liability if they report lower animal abuse or animal neglect, but they're not required to. They are required to report suspected aggravated animal abuse. So these are good definitions to familiarize yourself with. And to head a typical question I get off at the pass, I've now talked about cruelly killing an animal, and I've talked about maliciously killing an animal. And those are two different things, and there's case law to support that those are two different things. You could do one and not the other, or you could do both at the same time. Essentially, cruel, when you're talking about cruelly causing the death of an animal, it has to do with the manner of killing. We've all heard of humane euthanasia, right? So a cruel death would be the opposite of humane death. So that has to do with the manner of the killing. Maliciousness means intentionally acting with a depravity of mind and reckless and wanton disregard of life. So you could have a totally humane death if you're killing an animal to get back at an ex-girlfriend, to upset your kid, to show the animal who's boss, you kill the animal. That could be a malicious killing. And my illustrations down here, I think, are a little cryptic, but I had a case in Salem where a man trapped his neighbor's cat in a humane trap and just left it out in the sun. The cat died, and he threw away the body. And his defense essentially was, I didn't know whose cat that was. I thought the cat was sick. I was going to get around to taking it to the Humane Society. I just didn't get around to it. So what the judge ultimately said was, I don't think this was a malicious death. I don't think beyond a reasonable doubt that I could say he did this maliciously, but it was a cruel death for that cat to be out in the sun. And he heard testimony from the veterinarians about what that would have done to the cat, how that death would have happened. So that's a cruel death that's not malicious. And then over here we have, the famous National Lampoon poster of somebody threatening to shoot a dog in the head. Probably not a cruel death on balance because the dog dies right away, but certainly malicious, especially if you know who that dog belongs to, and you're doing it out of spite or with reckless and wanton disregard of life and depravity of your mind. Let's jump over to animal neglect, because these are the bulk of the cases, in my experience, that you will see. They're the bulk of the cases that you'll get called about, and it's important to know what it is you're looking for. The keystone of animal neglect is failing to give minimum care to an animal in your custody or control. So unlike the abuse statutes, you cannot neglect somebody else's dog or somebody else's cat or somebody else's fish unless that person puts you in charge of the animal, such that you were required to give that dog food every day, feed the fish, walk the dog, whatever it is. So you have to already have some legal obligation to care for an animal. Boarding facility that has some kind of agreement where they're going to feed a horse, something like that. Minimum care is further defined in the statute, and this is an edited version of the statute. So don't take this and pretend like this is all of it. There's more in there, and I don't want anybody to think that this is everything. This is edited down for space and clarity. Generally speaking, the headline of minimum care is care sufficient to preserve the health and well-being of an animal. Full stop. It includes very specific things in the statute, but the statute also says that it's not limited to the things in the statute. One thing that I found out very quickly when I started prosecuting these cases is that the statute doesn't mention hoof care. And any veterinarian that's worked with horses, any rescue agency that's worked with horses, anybody that's owned a horse here in the valley or any part of the state, east or westward, knows that hoof care is an essential part of caring for your horse. Because if you don't get them the hoof care, the hoofs crack, they get parasites, they get laminitis, et cetera, et cetera, et cetera. It rolls downhill. The entire health of the horse is built on the hoof care. Hoof care is not generally, in my experience, thought of as veterinary care, although I guess it could rise to that level. But again, hoof care is not included in this definition. So what do you do if you have a case where the issue is failure to care for the hooves? Well, is that care insufficient to preserve the health and well-being of an animal? A vet, a farrier, may come to you and say, yeah, this horse was suffering. It did not have its health and it did not have its well-being because of the insufficient hoof care. And so you go under this catch-all statute, is not limited to. So you say to the judge, we want a special jury instruction about why hoof care is important to horses. The things that are included are pretty obvious. Sufficient quantity and quality of food to preserve their body weight, open access to potable water. It says that you can't just use snow and ice as a substitute for potable water. Veterinary care, adequate shelter, space for exercise for domestic animals, good air temperature for domestic animals, reasonably clean and free for domestic animals. And again, when we're talking about for domestic animals, the statute explicitly says that domestic animals need these things. It doesn't say that there aren't circumstances in which a livestock animal may also need these certain things, or a horse may also need these certain things. So if you have somebody who has a horse, for example, that's suffering from rain rot, needs a blanket, needs to be inside, needs to be out of the weather. And if it's not, then that falls under this issue of is not limited to. And then for livestock animals that cannot walk or stand without assistance, euthanasia. And again, that's not to say that domestic animals might not need euthanasia, but the statute wanted to be very clear that that is a situation in which an owner, somebody in control or custody of an animal, has to act. So that's minimum care. We talked about criminal negligence. The person only has to fail to be aware of the circumstance. And that can be established in a number of different ways. My favorite way is them saying it on the stand from cross-examination. I'll say, isn't it true you had no idea that you were risking your animal's life? And they'll say, yes. And then I'll just say that right back to the jury in my closing argument. They told you. They failed to be aware of this risk. But you can also do it in other ways. If you're a prosecutor, what I've tended to do is ask people who are my witnesses, maybe not even in related areas. Maybe it's my animal control officer. Maybe it's my veterinarian. What is a reasonable expectation of what this animal would have gotten in this circumstance? You've owned horses for 20 years. What do you do for your horses when they get showing these kind of signs and symptoms? Because the keystone of this, and actually the keystone of a lot of things in the criminal justice system, is what would a reasonable person have done in that circumstance? And it's especially important in this criminal negligence context because it's about what the person didn't even know that they were supposed to do. So don't feed your cat like Garfield, and do feed your dog. There's a statute about animal abandonment. Animal abandonment is a misdemeanor that involves leaving a domestic animal or equine at a location without providing for their minimum care. These are horses getting dumped or kittens getting dumped on the side of a road or puppies or what have you. And it is not a defense that the location was a place that would provide those kind of services if you just knocked on the door and asked them. So you've probably all seen a lot of these kind of signs. Got a little wonky on the formatting here, but warning, it is unlawful to abandon animals at this location. This is a Class B misdemeanor, so it could net you 6 months in jail. Probably won't, but it could net you six months in jail. And it's good to put people on notice, both because you want to give them a chance to conform to the law, and because it's better for the animals if they're actually checked in at the animal shelter. And most animal shelters will happily take animals. What they do with them after that might be different from place to place, but that's what they're there for. So once a person is convicted of an animal cruelty crime, the general rule is that they have a ban on possession of certain kinds of animals. And again, I'm speaking in generalities because the law just changed, which I'll talk about in a minute. But generally speaking, if you're convicted of a misdemeanor level crime, it means for 5 years after you're convicted, you're not to possess any domestic animals, no matter what animal you were convicted of neglecting or abusing, any domestic animals, or any animal of the same genus as the animal was which you committed the crime against. So if you neglect a horse, if you neglect a horse for 5 years, you can't possess any domestic animals or horses, donkeys, zebras. If you neglect a cow, I'm not even going to try to guess what other animals are in the cow genus. Do you know? No? If you neglect an alpaca, you can't possess domestic animals or alpacas or llamas. Right. You had a question? This is automatic. So this is a statute which is not connected to sentencing provisions. This is a law. This is if you do this within the 5 or 15-year period, if it's 5 years for a misdemeanor, 15 years for a felony, you've committed a new crime. Now, there's a new provision in the law which allows a sentencing judge to keep a person from facing this prohibition. And there's also a relatively new provision in the law which says that this does not kick in on a person's first animal cruelty conviction, assuming that it was not intentional or knowing, and assuming that it was against a livestock animal. So it's a very complicated statutory scheme. This crime, even in the best of circumstances, is difficult to prove because obviously most people don't parade their animals around town, especially if they've been previously convicted of animal cruelty. They keep them locked up in their house or in their barn and try to keep, looky-loos from getting out there. But it has been prosecuted successfully, and it is complicated to figure out sometimes whether a person is subject to that prohibition or not.
The reason they asked them, we're in a case right now that deals with that same topic. The individual was prosecuted successfully in Orange County 4 years ago. Mm-hmm. But they placed inside the probation period an 18-month cannot own any animals.
Right. So that's a separate issue. So when a person's put on probation, judges have a lot of latitude to give people lots of different conditions. And I will always ask on my cases, and most people prosecuting animal cases will always ask that a condition of probation be no animals, period, full stop. The maximum amount of probation that you can get on an animal case is 5 years, whether it's a misdemeanor or a felony. You can only be put on probation for 5 years. So on a misdemeanor, I'll ask for a 5-year probation, especially after trial. I have no problem asking for a full max probation with a full max, prohibition. The trick is, I guess, on a probation violation, you are depending on a judge really caring about following through, because typically the judge is going to be the PO, and the judge will have to okay both it being a violation and any kind of sanction that the person's going to get. On a felony, maybe you have a PO that you can work with and talk to about making sure that the person doesn't have animals or what have you. On a crime, the judge has a little bit less latitude. And of course, when it comes to sentencing, they have latitude. But in terms of did this person commit the crime or not, typically they will go along with what happened. So it's good to have this statute. It's probably easier to work through a probation violation because probation conditions are typically more clear-cut than this kind of mess, which gets you into sort of statutory construction, trying to figure out, is this the person's first conviction? Is this person subject to an exception? Back and forth.
Prosecuted successfully in 7 different states for similar crimes.
Well, okay. It sounds like then it would be worth trying to at least figure out if he falls under this statute. That's something that the DA's office, or I could help you out with, just trying to detangle that.
You and I will work on it right now.
Perfect. When you have an animal case, the thing that sort of makes it unique to almost any other criminal prosecution, criminal investigation, is that you have living, breathing evidence that needs to be given minimum care, at least. And one of the things that complicates that is the timelines of criminal trials are a nightmare, especially in more rural counties. If you have a criminal felony case or a misdemeanor case, you can expect that you're going to be 6 months, 9 months, a year and a half before you see a resolution of that case. And in the meantime, you don't want the defendant owning the animal, and you don't want to have to pay what it's going to cost to hold the animal in abeyance, essentially, until the case, is resolved. So what the law has created is a pretrial forfeiture procedure. And what this aims to do is to get care for these animals and also give the defendant an opportunity to defend, their ownership if they want to, and also gives them an opportunity to avoid the animals getting forfeited if that's what they want to do. The way it works is this. You have a criminal case pending. You have animals that were seized by a law enforcement officer, and they've been impounded, and they're being held either in the county animal shelter or an animal care agency, which is essentially, an agency that cares for animals for the county. You have to give notice to the defendant and any other potential owners that you're going to have a hearing, and then the court schedules a hearing. The hearing is a contested hearing, so the defendant can stand up there, put witnesses up, cross-examine the state's witnesses, and any other person who has an ownership interest in the animal can also do all those things. So it can turn into a little bit of a circus, especially if you have, one large seizure of 100 animals and 25 belong to one person, 50 belong to another person. But it's worth doing. The decision that the judge has to make is essentially a probable cause decision. The judge has to decide, is it more likely than not that at the time of the seizure, these animals had been abused or neglected? And if the judge says yes, then the second decision the judge has to make is how much money has it cost to care for the animals to date? And how much money is it going to cost to care for the animals until we get to trial? Take that whole lump sum and establish a bond amount. And when they order the animals forfeited, also say in that order that order may be stayed, so it doesn't go into effect, if the bond amount is paid. Bond can be paid by anybody. I've heard of people doing like fundraisers to try to pay their bonds on these kinds of things. But the nice thing about that is that the county gets that money to care for the animals. So they can start dispersing money out to feed stores and veterinarians and whomever has given them care. So it makes it less likely that people are going to be just doing this and as a losing proposition. There's an important recent amendment to this statute. which I think is really important to know about, really crucial for everybody involved in the system to know about. Previously, it was a bit ambiguous as to whether a criminal charge had to be pending for each animal that you were requesting forfeiture on. So you would have maybe, just as an example, law enforcement would go in, would seize 120 animals. The district attorney would get the reports, would end up issuing charges on 65 of them. And then the question for the court was, well, what do I do with that additional 55 animals? Can I order forfeiture even though there's no criminal case pending for those animals? And there are judges that I know who've said, no, I can't. And there is an argument that, no, they couldn't under the old statute. But the statute has recently been amended to say that if there is a criminal case pending for any of the animals involved in a seizure, then the court can do a pretrial forfeiture on all of the animals. And the thing that this protects is essentially prosecutorial discretion, because the police are one level of review, and then prosecutors get a case, and they want to put on their best case. They may not want to throw, in some cases, I've had 250 charges that I could file against somebody, and that gets ridiculous, both in the size of the case and also the relative value of going forward with that many counts versus getting really good, strong counts, putting your best case forward. So this new provision makes it clear that you can take your best cases, charge your best cases, and still move for pretrial forfeiture on all the animals. I would be remiss if I didn't mention that it is much easier from a prosecution standpoint if, when you are seizing animals, the owner of that animal says, I surrender the ownership of this animal to you. That is always my first step. In a case where they didn't do it at the time of the seizure, I will call the lawyer and say, do you want to go through this process, or do you want to talk to your client about surrendering the animals so we don't have to drag it through this whole process? So that's always the quickest, cleanest way to do it. You may have animal ownership issues, in which case you may want to talk to your district attorney or your county council about what you want to do in terms of those animals, but always easier to get permission than to beg forgiveness, I guess, or to go through this forfeiture proceeding. I want to go through a couple of cruelty law updates. I'm still doing okay with time. Good. In 2013, around the same time I started doing this work, the legislature proposed and passed a huge set of laws called Senate Bill 6. Senate Bill 6 was spearheaded by Senator Courtney, Senate President Courtney, and it overhauled a lot of the ways that Oregon deals with animal cruelty cases. One of the main things that it did was created the crimes of animal neglect as a felony in the first degree and second degree. In 2014, I took one of the first animal neglect felony cases in the state to trial and got a 36-month prison sentence, whereas before, that guy would have just been looking at, misdemeanor, 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 misdemeanor. He was actually a felon and was convicted as such. So they added, also in 2013, a section of legislative findings. And there are very few cases that I have where I don't refer to these legislative findings in some way or another when I'm talking to a judge or a defense attorney. And I'll just read you a couple of them because they're pretty striking to me. This is Oregon law, and this is something that can be cited in a closing argument. It can be cited when talking to a defendant. The Legislative Assembly finds and declares that animals are sentient beings capable of experiencing pain, stress, and fear, Animals should be cared for in ways that minimize pain, stress, fear, and suffering. The suffering of animals can be mitigated by expediting the disposition of abused animals that would otherwise languish in cages while their defendant owners await trial. So I will very often stand in front of a jury and say, look, it is the law in Oregon that animals are sentient beings, that they are capable of experiencing pain, stress, and fear, and that is what this animal experienced in this case. That's why we're here. They included that language in a 2016 Supreme Court opinion, which I'll talk about in a few minutes. They put that language right in there because it was so strong to the point that the Supreme Court was making in that circumstance. Other things Senate Bill 6 did is it increased the crime seriousness scores of aggravated animal abuse and animal abuse in the first degree as a felony. If you're not in prosecuting people, then you may not understand what that means, because when you hear about Class C felonies, what the media tells you is that the person is facing 5 years in prison. What they don't tell you is that that 5 years in prison may be impacted by what's called the sentencing guidelines grid, which is this horrible looking mess of a chart, which tells you and tells the judge exactly how they may sentence a person after they've been convicted of a felony. Essentially, before 2013, before these went into effect, a person convicted of any animal-related felony, no matter how bad their criminal history was looking at a probation sentence. And now, if you're convicted of aggravated animal abuse or animal abuse in the first degree as a felony or any of the animal neglect felonies, you could be looking at prison depending on how bad your criminal history is. Senate Bill 6 also clarified the notice provisions, the pretrial forfeiture that I was talking about before. Previously, there were no specific rules about how to notify people that their animals may be forfeited. Now you can go to the newspaper and publish a notice, which, you know, we all read our newspapers first thing in the morning, right? And we flip to the notices section to see if we're listed in any legal notices. But that put it in there so that we can cover our bases if a person is in warrant status or if you don't know who the animal owner is. It also created regulations for animal rescue entities, which one of the big problems that people would see is that organizations posing as animal rescuers were actually some of the worst animal neglectors and abusers. They were hoarders. They were people that just wanted to get as many animals as they could, and they didn't care that they were in bad shape or they were putting animals together which shouldn't be put together. So this created regulations for those entities. They're fairly broad, but they need to be enacted on a county basis in order to have any teeth, because the counties are the enforcing agencies, essentially. So I don't know if Klamath County has animal rescue entity laws, but they do? Okay, so they do. So those should be registered, licensed, and inspected as needed. This year, there were a few animal law updates that I'll talk to you about. The main one, the biggest one in my mind, is that one about seized animals not needing to be included in the criminal charge in order to be forfeited pre-trial. I think it's just such a huge. I last year put together a 200 count indictment for literally 200 counts for cattle in Hermiston. They had to go through and they had to tag each and every cow. And I had to go through and look at each cow's body condition score report and make sure that each one met the definition of neglect. Because I was worried that if I didn't have a 200 count indictment, that the judge, if we got to a forfeiture hearing, would say, I'm sorry, I'm not going to forfeit those animals. And then we'd be in trouble. House Bill 3177 added chicks and hens to cockfighting definitions. You may be surprised to know that cockfighting only involved the male roosters previously, but the Oregon Humane Society knew that based on some cases that they'd worked on, and they knew that they couldn't technically seize the chicks, which some of them would ultimately become the fighters, or the hens, which were obviously breeding the fighters in those cases. So 3177 added those birds to the definitions. 3283 increased the possession ban for felony neglect to 15 years. It had been left at 5 years due to an administrative oversight in 2013. So now if you're convicted of felony neglect, it's a 15-year ban. It also stated explicitly that a judge, when sentencing somebody for an animal cruelty crime, could not take money away from an animal care organization based on the fact that they had done fundraising relative to their work. So this came up on a couple of cases that the Oregon Humane Society worked on, where the defense attorney argued essentially, yeah, we know they spent a lot of money caring for these animals, but also they raised funds. They did fundraising efforts and they raised all this money. So really, Judge, you shouldn't give them more money because that's essentially double dipping. And what this law says is the judge is not supposed to take that into account. Now, judges have a lot of latitude at the time of sentencing, and I've seen judges just chop restitution numbers in half just because they feel bad for the person. So it doesn't always work out, but at least it's in the law now. It also announced that parrots are not livestock, which I guess was a consideration at some point. They thought that parrots were livestock, so they had the psittacine, is that how you pronounce it? They were included in the livestock definition, and now they are no longer. And the one that everybody asks me about, even though it doesn't really come into play with my work, is the dogs in hot cars law, which passed and is law. I'll just say as an aside, it can be animal neglect if you leave a dog in a hot car. It depends on a lot of things, and obviously you want to try to be conservative about charging somebody with a crime that's going to take their animal away unless you have a very valid and solid basis for doing something like this. When I get dog in hot car cases, unless they are extreme, the dog dies or something, or it's a repeated occurrence, I will try to work to work it out, especially if the animal control officer says, yeah, I let them go with their dog. I'm going to try to work it out so that they can keep their dog, and they also get some education around this issue. Because once you start learning about dogs in hot cars, you lose your mind, because it's a really bad thing. It happens so fast, and there's a reason why this law went into play. So the deal with this one, I'll just talk about it so that if you run into it, you can deal with it. This is how this new law works. A rescuer, and I'm calling them a rescuer just because that's what they are intending to do, not because necessarily that's what they are doing, but that's what their intended goal is. Rescuer sees an unattended child or domestic animal in a motor vehicle who cannot exit without assistance. Okay, so this is strapped into a seatbelt for a kid or any animal, as long as the window's not down so they could squirm out if they needed to. The rescuer has to form a good faith and reasonable belief based on the circumstances that entry into the motor vehicle is necessary because the child or the animal is in imminent danger of suffering harm. There's a lot of very specific language in there. This is not a break your neighbor's window law. This is a be very, very concerned because of something you specifically saw and you specifically know about the situation. And to help people know this, I put this chart up, which is from a study that was done on cars. They'd put a car in the sun, they'd measure the ambient temperature inside, they'd let it sit. A 70-degree day a car increased to over 100 degrees in just a half an hour. On a 90-degree day, is like desert temperature in the same amount of time. So it can get very drastic very quick. It's something that I think is getting a lot of attention and a lot of people do know about, so I'm a little bit less sympathetic to people that leave their animals in the car. But that's so that you all know how bad it can get. Once the rescuer has formed that good faith and reasonable belief, they are allowed to enter the vehicle using no more force than is necessary and remove the child or the animal. That means if the door is unlocked, they shouldn't be breaking the window. And if the door is locked, then they shouldn't be breaking 4 windows. But, people get heated about this kind of thing. Pardon the pun. So they're allowed to enter the vehicle and remove the child or the animal. They have to notify law enforcement or emergency services before they do it or as soon as practicable after they do it. And they have to stay with the child or the animal, either at the vehicle or as close by as they can, until the driver gets there or until law enforcement or an ambulance arrives. So this is not also a situation where you can just damage your neighbor's property or some person at the grocery store's property, get a kid or a dog out, and then take off. You can't take the dog and now it's your dog. You have to stay there. You have to you have to meet the person or at least meet the law enforcement officer that's tasked to deal with that. If you do all those things appropriately, under those circumstances, you will not be liable for criminal or civil penalties. So if this is, then the person's mad at you for breaking their window and they try to take you to small claims court, the judge throws it out. If the person calls the police and files a police report and it gets to the DA's office, DA takes a look at it and it fits all these categories, the DA presumably no complains it. If for some reason the DA does not no complain it and you're prosecuted, the judge should, take care of it on that end because it's a defense to what you did. And the main thing that I saw people complaining about is, this is just going to give all these punks in downtown Portland license to break my window because they're going to say that they saw a dog. But remember, you got to have a good faith and reasonable belief that entry is necessary. And you got to stick around, which, I don't know, when my window got broken in downtown Portland, they did not stick around. I don't know if your experience with that is any different. So, any questions about that? Okay. There are exceptions and exemptions to everything, and the criminal laws of animal neglect and animal abuse are no exception to that. The big headline is good animal husbandry practices are never animal abuse. So if it's something that farmers have done and do in the practice of good animal husbandry, things that may horrify city folk are not considered crimes. Docking tails, dehorning animals, castration by whatever appropriate medical means, not animal abuse. So, and then unless gross negligence is shown, most Oregon animal cruelty laws do not apply to any of these activities. Treatment of or lawful killing of livestock, rodeos, good animal husbandry, veterinary practices, hunting, fishing, trapping, teaching, pest control, things like that. So these are defenses that you may run into. It's not to say that a person involved in a rodeo or a person involved in livestock killing can't abuse an animal or neglect an animal, but it's harder to prove than just a garden variety abuse or neglect case. I want to talk a little bit about case law. This is mainly an issue for the law enforcement folks, and it is when you are called out on an animal case and you don't yet have a warrant, can you seize the animal? Can you search the property for a hurt or neglected animal? In State versus Fessenden, a law enforcement agency was called out on a report of an extremely emaciated horse, which was just over a fence. They could see over the fence, they could see the horse, it was standing on the other side of the fence. But that's enough, as law enforcement officers will tell you, that's enough to trigger privacy and to make it so that in all things being equal, you need a warrant to go over there. Fortunately, the officer that came out had some background in animal biology and was able to say that it was an extremely emaciated horse that was in danger of essentially dropping dead any minute. Also observed that the horse's urine was syrupy, which he recognized as a sign of protein breakdown, and desperate medical intervention was needed, and took the team over and they rescued the horse. And that person filed a motion to suppress all the evidence that was gathered from the seizure of the horse, saying that they violated his rights when they didn't get a warrant to do that. The Court of Appeals looked at those facts and said that animals can also fall under what's called the emergency aid exception. So, well, I'll get to that in a second. So this is an emergency aid situation where there's a reasonable belief that the search or seizure is necessary to render aid or assistance to animals that are suffering unlawful, serious physical injury or cruel death. That's a very narrow kind of definition, because you have to basically know as an investigator that your immediate aid will help an animal avoid serious physical injury or cruel death. Supreme Court also got a chance to take a look at this case, and what they said is exigent circumstances apply in this case. They didn't say that emergency aid did not apply. They didn't go back to the Court of Appeals and say the Court of Appeals was wrong, but they said we're going to decide it on a kind of a narrower basis and say that the police officers had developed probable cause. That officer knew that more likely than not, this animal had not been given minimum care, so he developed probable cause that a crime was in progress, and felt that an immediate activity, warrantless activity, was necessary to prevent an ongoing act from causing further serious imminent harm to the victim of the crime. So it's a little bit of I actually think it gives you officers a little bit of a wider berth, because it's just serious imminent harm. It doesn't specifically say serious physical injury or cruel death. But these are two bases that officers for years had used in human cases. If you have exigent circumstances, that's a classic example of a time when you can go in as an officer without a warrant. Or if you're trying to give somebody emergency aid, that's another classic example. But what the Court of Appeals said, and then the Supreme Court said, is both of those are exceptions to the warrant requirement, even when the victim is an animal. Yes?
I'm going to have a hard time with that. I'm
Okay.
going to say our rule is the Oregon Supreme Court. The Oregon Supreme Court decided our rule. From the standpoint of not getting them returned in the future, I'm going to say we do it on exigent circumstances. That's
what we've done before.
Yeah, that's what I want you guys to articulate. I don't want to rely on a Court of Appeals decision and have ourselves overturned.
That's fair. That's fair. My reading of this of the ruling is that it doesn't overrule the Court of Appeals. It just decided it on a different basis. But you certainly, that's certainly a setup for later on the Supreme Court to say emergency aid does not apply.
Right.
It's an open question.
They told us what the rule is.
Right. So you've got an exigent circumstances. That's a good solid rule. Of course, I think you would probably agree that if you have time to get a warrant and an animal is not going to die in the meantime, then go for that.
But we've used this many times.
Yeah. State versus Newcomb is a case that came out last year. This was the case of Juno, which was a dog that was reported as being emaciated in Multnomah County. Oregon Humane Society officer went out, knocked on the door, just talking to the animal's owner, was able to see that the animal was emaciated. If an animal control officer is in a place where he's legally allowed to, he can ask for consent and take the animal. The officer did seize the animal at that time, did not have a warrant, took the animal back to the Oregon Humane Society where Juno's weight was tested, fecal matter, they did some blood testing, all that kind of internal testing. And then they did weights along the way. When the case came to trial, the defendant said, well, wait a minute, my personal privacy interest in my dog's internal contents was violated. Very similar to how if a police officer had seized a backpack on my back, they couldn't just open it and go through every closed container just because they wanted to. And what the Court of Appeals initially, well, the trial court disagreed. Court of Appeals initially agreed with the defendant and said, you're right, you do have a personal privacy interest in the internal contents of your animal, such that the state can't go into it like that. And the Supreme Court basically said, that's ridiculous. Nobody uses their animal's chemistry to store anything that they consider private. Nobody is putting any, and they did say, to their credit, they said, if it was a case where somebody was using their animal to hide jewels or evidence, then maybe you'd have a different circumstance. But in the general rule is that if you're just giving care to an animal that you seized, it doesn't run afoul of the owner's expectation of their privacy. Now, what I always prefer to have happen is a defendant to explicitly say to a seizing officer, you can give them whatever care that you want, even if the person is saying, I'm not relinquishing ownership. And this is something that you may want to have on your forms even, where there's an option to say, I hereby relinquish ownership of this animal, which means you can do whatever you want, or I do not relinquish ownership of this animal, but you may provide it with veterinary care to which the vet sees fit. So this is a great case, and it's very helpful. It's better if you can avoid the issue altogether, but it definitely makes our job a lot easier because animals obviously can't talk and tell you what's wrong with them. Sentencing case. This is my alpaca case from 2014, the felony case where the guy got 36 months. You'll notice that the tarp is being consumed here by one of these animals and is seeking food. They were also gnawing on each other's backs, trying to get whatever protein they could out of their damp, wet fur. And although they don't look too bad, that is an optical illusion with alpaca, because as soon as you put your hand on these furry animals, you just felt nothing but ribs. So that was my alpaca case. And the reason why I bring that up is because in State versus Nix, which is the 2014 case, and then ultimately State versus Hess, the 2015 case, the Court of Appeals said that if you neglect multiple animals in a single incident, you get multiple convictions. And what the defendant in, not this case, but in the case in Nix and Hess wanted the court to give them one conviction for neglecting, 12, or in Hess, I think it was 43 different animals. So that's just an issue of sentencing. Obviously, with sentencing, it could impact the jail time that they could get. It could impact the ability to expunge a conviction. If you have one conviction versus multiple convictions, you can expunge it a lot faster. So an important and good result there. Does anybody have any questions about, I know I've been talking for a while, the law or cases or case law? Any specific issues that you've all
I
had?
have a question
Yeah.
on the forfeiture law.
Yes.
It used to be when it first was enacted, I think in '93, that you had 14 days after your animals were seized to file a forfeiture in court.
Right.
And then hopefully by that time, the bond was put up, and then if the guy didn't pay it, and the court decided if they needed the animals to be held over, and they were either released to the animal care agency
Yeah.
or held over if they did pay the bond.
Right.
So is that still
It is
basically the same?
it is very different now. The only thing that triggers a forfeiture is the filing of a petition by the county or by the agency that's holding the animal. There's a weird sort of provision in there that I imagine it was built in for like the larger animal care organizations like Oregon Humane Society, so they can bring a separate action to get this done. But that's what triggers it, is the state or the county or the animal care agency files the petition, and that can happen anytime. Once the petition is filed, the court is instructed to set a hearing within 14 days. But there's a provision that says, or whenever practicable, which allows the court to say, well, we're going to have this hearing in 2 months. Or we're going to have this hearing, basically never. Then you get the hearing set. At that time, if the person has been given appropriate notice and they don't show up, a court will often kind of enter what's sort of a default on it, which will just allow the state to proceed with the forfeiture. They still have to build in a bond amount, so I typically will tell prosecutors, even if you're not expecting your defendant to show up, you should make sure you show up with your witnesses so that the court is satisfied that you've done your job. And then once the order is entered, the defendant has 72 hours to come up with the money, or the order goes into effect. So it's sort of a reverse of what you were saying in terms of burdens and how much it takes. It speaks to the dual nature of animals as both victims needing care and property in Oregon law, which is the tension that very often comes up in my work. So they want to make sure that people's property rights are protected, but they also want to make sure the animals are protected. Any other questions for that? Still have some other things to talk about. Good. Okay. Investigation and evidence collection. This is one of the things that trips people up a lot. There's so much evidence, we should put some aside for a different case. Bad practice. But very often, who you're going to have involved in serving your search warrant or then caring for your living evidence are people that are not familiar with chain of custody issues, are not familiar with evidentiary issues, are not familiar with testifying, things like that. So it's very important to go over these kind of things. I'll go moderately fast through this section because I know we've got people who do this for a living as well. Evidence in court is admissible testimony and exhibits. It's what the fact finder, either the jury or the judge, is going to use to make a determination as to whether the person did the crime or not. Testimony is what a witness says while they're being questioned on the stand. Exhibits are physical objects, photographs, charts, and letters. In an animal case, it may be a carcass, it may be a vial of blood, it may be a gun that was used to kill an animal. Hopefully it's not a living animal. It is a mess trying to bring living exhibits into your courtroom, but I have seen it done by defense attorneys on occasion. It didn't go well for them. So exhibits are also things that the jury is going to be able to look at, going to be able to hold, and going to, depending on your case, be grossed out by if you're going to put in a lot of necropsy pictures or things like that. So in order to get that information in front of the jury, however, evidence has to be authenticated, which means that is this evidence, has somebody testified that this evidence is what it claims to be? Does the person, the proponent of the evidence, the person who's testifying about the evidence, have that direct knowledge, because one of the things that the court system protects defendants against is being convicted based on hearsay. He told me that this was the lab report that came back. He told me that this was a fecal sample from that dog. Not going to necessarily cut it when you're in court. Was the evidence altered or tampered with at any point? And this is all important things for a prosecutor to be able to present to the court, because if we can't prove our case. When you're going out to do evidence collection or an investigation or a search warrant on an animal case, I put together a list of some helpful things to have. Cameras, I mean, it's obvious, but the amount of time that people find themselves in the field and they don't have any way to record what it is that they see or are seeing is staggering. I mean, in a pinch, you know you have a camera in your pocket, right, on your phone. I prefer people not use their personal devices to record evidence, because we get into all kinds of mess with that. But, if that's all you've got, then that's the best way to record it. Every digital camera that you're ever going to own has an option to turn on date-time stamps. So it means it says right at the bottom of the picture, this was taken on July 9th, 2016, at what time. You have to set it up, though, and you have to make sure that it's right before you start snapping pictures, because otherwise it's not going to show up there. So make sure that your evidence collection equipment is ready to go before you get out there. Thermometer, and this is more for ambient temperature, because one of the issues is air temperature, air quality for animals. Ammonia sensors that you know how to use, that you've used before in good conditions, so that when you're in an investigation in bad conditions, you also know how to use them. Flashlights, batteries, these are all pretty obvious things. Diagnostic supplies, if you're going out there as a vet or you're going out there assisting a vet, you need to have everything that you're going to need to make diagnoses on the ground. You may, in a good situation, be able to then take the animal back to your lab and do diagnoses there. But it would be best if you could do as much work as you can on the scene. If biological samples need to be preserved, a cooler, bags, pens, markers, placards, right erase boards. If you've got 150 animals that you're going to have to take off of a property, a really good way to keep them straight is to take a picture of them with a placard next to them. This is animal number 3, this is animal number 4, this is animal number 7. A scribe is a really good thing to have for a veterinarian, and for the animal officers in the crowd. When you go on a warrant, you're allowed to take people with you that are not police officers, as long as they are there to effectively serve the search warrant. So if your vet wants to bring somebody that they always have with them out to the scene, that always works with them, that's their best practice, then I think that's a good idea for you to have as well. There is a handbook made by the Oregon Humane Society, which is a good thing to have with you. It contains all the laws and some contact information, and allows you to go through and see what it is you're looking at. When you're assessing a scene, it's important to get a bird's eye view of everything, and then also a close-up view of everything. So you want to know exactly how many buildings, how many sites you're looking at, how much, what type of food is available, even if it's not out. What's being stored? Is there anything in that barn over there? Is there anything in that barn over there? How much water is available? What's the source of the water? Take samples of the water. How much medicine is available? How many nutritional supplements? Do they have expiration dates on them? Are all the vaccines expired now 2, 3, 5 years? Is there appropriate shelter for each and every animal? Are there environmental dangers out there? Document, document, document. The more pictures that you have, the easier it is to then convey in 3 months, 6 months, 9 months to a group of people that were not there with you on the day, how bad it was. Chain of custody is a huge issue that we run into in all criminal cases, but especially in animal cases where there are agencies handling evidence that are not the police. You know, when a police officer pulls somebody over and ultimately arrests them and takes their items and puts them into the evidence locker, they have a procedure in place to say, I took it from here, I gave it to this person, they wrote it down, they put a sticker on it that said, was logged in at this time, they put it on this shelf, they know that nobody messed with it, they locked the door at the end of the day, and they left, they came back, and now we have it here for you at trial. We know how it got from point A to point B. In an animal case, you may have veterinarians involved, you may have animal shelters involved, animal rescue agencies involved, and they need to know, they need to be made aware that the best way to get evidence in front of a judge is to be able to say, Judge, we are confident that this evidence was handled properly, was not lost, was not damaged, was not tampered with intentionally at any stage of the game. So proper chain of custody procedures are key. The one area where I think this is hugely problematic in animal cases is, so say I have a rape case with DNA. That DNA is going to the state police crime lab, where they, again, know about chain of custody. They know how to handle evidence, at least theoretically, so that it doesn't get lost or tampered with or deteriorate. If you get an animal sample that you want tested for proof of neglect or proof of abuse, and you send it to a private company, I'm not naming any specific names of any private companies, but those samples may be going to California, if you're lucky. They may be going to Michigan. They may be going to Maine. And once they get to the lab where they're going to be tested, you may find out that they batched that sample together with other samples, and that the lab technician ran it and could not tell you when the result came up for your sample that it was tied directly to your sample. And you may find out that that private lab company doesn't keep track of which lab technician works on which sample. And the reason that I mention this in such a sort of dire tone of voice is that the U.S. Supreme Court has said that lab technicians have to be witnesses. Essentially, they have to be able to be confronted on a case where the lab results are at question, because we have that right to confront our accusers, right? We can cross-examine the witnesses against us. And if all I have to prove a lab result is a piece of paper, this is the lab result, a defense attorney cannot cross-examine a piece of paper. A defense attorney cannot say to that piece of paper, was the machine that generated you working on the day that you generated that piece of paper? They can't say, was that test run in accordance with your standards and practices? They can't say, was that a normal result? Were there any error messages? Any of those things. So to the degree that you have labs issues and you're going to be testing evidence, those calls need to be made before the evidence is sent to those labs. Those calls need to be made, and you need to make it explicitly clear that what you want is testing done by a discrete member of their staff who will, if they are out of state, accept service of a subpoena for a criminal case. Because generally speaking, it's possible to drag somebody into Oregon to testify in a criminal case, but it's difficult. It's not an easy proposition, and I don't think any DA wants that on their desk of having to go to another state, because it involves convincing a judge in another state that you want this done. So they can just tell you, basically, I'm not coming. I'm going to make this cost prohibitive for you, and then your evidence is gone. Now, in a lot of cases, defense attorneys may be willing to allow you to present evidence that doesn't have this explicit chain of custody. But if you can't represent to them that chain of custody is something that you could establish if they put your feet to the fire, they have no reason to agree to that. They have no reason to say, oh yeah, sure, bring in the very, very bad evidence against my client. I'm not going to put up any fight about that. So check in advance. The other thing is that there are labs in state. The Oregon Humane Society has been working very hard to establish a very thorough animal science lab where they do testing like this. Oregon State University does a lot of testing in-house, although be forewarned that they do send labs out of state as well. If they need certain things done, they'll go out of state because they don't have the machinery here in Oregon. And if they're going to do that, just make sure that the lab tech is on the other end is going to be willing to come testify. Sometimes you can reach out to the defense attorney and say, will you agree that the lab tech in this case can testify by telephone because they're going to be in another state? And if they're nice, they'll say yes. And if they're not nice, then you start to scramble. Document, document, document. Keep track of where things go when. And this includes animals. If you have an animal cruelty case and you can't say for sure where each animal is at the time of trial and what brought it to that point, you're going to be in trouble. If you can't say who the caretakers were for the animal all along the way, you may be in trouble. Different kinds of samples need different kinds of storage. I learned this the hard way in a case involving a hay sample, which was seized at a cattle farm by method of reaching into the hay and grabbing out a sample and putting it in a paper bag and sending it to the lab. I'll tell you each step of that was wrong. The lab technician who ultimately tested the sample said that the appropriate tool for getting a hay sample would be a corer, which is a very expensive piece of equipment that you would not generally own or use unless you had a commercial-sized animal concern. You would want to get a core sample, and then you would need to store it in something that would preserve the moisture level, which paper bag does not do. The moisture just goes right out of it. So then I have a lab technician on the stand saying, what they sent me was pretty worthless. So here's what I can tell you about it, but it's not very, it's not going to really help anybody make their determination. So make sure that when you're seizing something, if you know in advance what lab you're going to, where you're going to send it to, ask them questions. What are you going to need to make a good determination on this? What information do you need? Do you need details about where it was seized from, when it was seized from, what the conditions were? Everything has a different handling protocol. You can ask Oregon Humane Society or the Veterinary Diagnostic Lab or the lab you're going to use about those issues. Here's another cute picture of these alpaca. It's cute until you notice that in the back this tree has its bark stripped up as high as these tall animals can go because they were looking for feed. When you're documenting seized animals, it can be kind of a nightmare, especially if you have dozens upon dozens upon dozens of unsorted alpaca or cattle or horses. So make sure you have a plan in advance. If you're going onto a property and you have a warrant, make sure you know what you're going to do before you get there and bring along enough team members. Again, you can bring along people, posse members, community members, animal rescue organizers or members, as long as they are there to efficiently help you effectively search and seize. For each animal, what I would love to have as a prosecutor is multiple pictures, showing them where they were seized from, showing them when they were removed from that environment, multiple angles, close-ups of any specific injuries or things that show neglect, especially on animals that show ribs when they're skinny. If we can see the ribs in the picture, that's best. If we can see the backbone, the scapulas, Update pictures are always good. If they are given new names, make sure that the new names are corresponded in some kind of document to the names that they already have. If you can keep small animals separated, that's best, so that you don't accidentally mix up animals. With dogs and cats and things like small animals, you can use collars to keep them separated. With cows, you're going to be looking at ear tags, things like that. Horses typically have enough markings that distinguish them, but if you have two horses that are very similar looking, be very careful about the pictures that you take with them. I've spent hours holding two pictures up and sort of going back and forth and saying, is this the same horse? Is this the same horse? And ultimately, you know, that makes everybody's job harder. Did you have a question?
I just went dealing with horses, cows, and cattle and stuff. I went to the sale yard and got some of the tags that they put on the cattle when they come through.
Yep.
Those things got to wear off and then they will come off.
Yeah.
You put that on them, they're numbered. Just each one's a different number, so it's easier to keep track of.
Yes, that's perfect. Yeah, because cattle don't distinguish very often. They maybe have like small distinguishing marks, but oh boy. Yes, numbering on the ear or the sticky tags are very good for that. Oh, this is a dog. I forgive you if you couldn't tell from the picture. It's a dog named Zelda that was seized in 2014 in Marion County. The Oregon Humane Society did this investigation. Again, just a neighbor called in and said, I saw this horrible looking animal being walked. Please go check it out. So they went out, and this is what they found. And the woman agreed to let the Humane Society take a look at the animal and ultimately agreed to surrender Zelda. What I like about this picture, I mean, not much, but in terms of investigation and evidence, it has a date, has a time. This is identifiably the defendant, can show how she's holding the animal in terms of this is a person who is very comfortable with this being the condition of their animal. You know, it's not just sitting on the floor and you don't, you know, a jury can really see this person didn't understand, didn't know, wasn't aware that this was a bad shape for their animal to be in. There's Zelda back in the sterile conditions of the lab. It is, as you can see on the tag, a Lhasa Apso. This again has the date and time down here, a case number, an evidence number, the name of the animal, the color, which is, you know, kind of a guess at this point. And then we get to see the after pictures. She's really cute. But close-ups on the eyes, which were extremely infected, were very dry, and ultimately, you know, the dog had a few weeks of good time at the Humane Society. Ended up getting put down for chronic things unrelated to the neglect, but was in a bad shape.
Quick question.
Yeah.
You've got a bunch of animals, they're being neglected. There's definitely a charge there, but the owner surrenders them. Can he still be charged with animal neglect?
Yes.
If he surrendered?
Yes, that doesn't impact whether criminal charges can be brought or not. That may ultimately impact, you know, the resolution of the case. One of the things that I often look at in making a determination of what kind of plea bargain to offer somebody is, were they remorseful? Did they do what was right for the animal? Were they quick to understand, I did something wrong to make this animal feel better? So this is another case. This was a horse and dog neglect case in Columbia County. Multiple horses seized, and this is on scene. Pictures were taken of the horse from all four different angles. You can see the backbone. You can see the what are the haunches called? What is that? Hips, hip bones. Yeah. See, this is why I rely on you all to know the technical details. What I loved about this set of pictures is not this set of pictures, but is the second set of pictures. This is the same horse a couple months later after being in care with people that actually, knew what they were doing. It's still shocking to me that this is the same horse, that you can see these colors popping on this same horse, and it was just such a difference to me. So this kind of set of evidence won the case, because a jury can't look at this and say she knew what she was doing. She just didn't know what she was doing. She was not aware of the level of neglect going on and was not providing minimum care for the animals. When you're testing animals, it's important to do your work the way that you normally would, no matter how the animal comes to you. That is to say, if you get an animal surrendered to your organization because it's a stray, or because it's a abused or neglected animal, or because it's relinquished to your organization in some other way, it's important to go through the testing the same way so that you're not looking like you're doing anything different for law enforcement. But make sure that you take pictures, take videos, make ultimate findings. This is mostly for veterinarians or people involved in animal rescue. You want to make sure that everything is documented, because when you see the animal, it's going to be another 6 months to a year before you're being asked to talk about the animal. Human memory being what it is, it's much better to have that written down somewhere than to try to rely on your own personal memories of the time and the date of the time. When you're doing a sample, testing of a sample, make sure that the chain of custody is good, as we said, and that the storage was done correctly. If you do the testing on premises, keep track of who does the testing. I ask in criminal cases that when vets do testing themselves, that they make sure that it's a trusted staff member who's been there for a long time, because sometimes vet offices will employ somebody for the summer or will employ somebody on a short-term basis. And if they're the tester of the sample and then they move to Los Angeles, and that's where we need them when it's trial time, then it gets tricky. So if you have somebody on staff that you trust to stick around and work with regularly, that's your best bet. They need to know how to do the testing, though. It's best if the testing equipment itself is calibrated right before the test, but if it's not calibrated right before the test, you need to know when the last time it was calibrated is. For our DUI cases, we have machines that automatically run calibration testing on a regular basis, and they spit out a report every time they do the calibration, and any DA can access those records anytime they need to show that before the breath test was conducted, the machine was working, after the breath test was conducted, the machine was working, so we can assume that when the breath test was conducted, the machine was working. So best to be able to do that in our cases as well. After the testing is done, were there any errors? Did the test results corroborate your assumptions? Did they conflict with them? It's very important, even if you get something that looks a little weird, to be upfront with that. Because the last thing you want to do is give your DA a piece of paper that has a dozen test results on it and not note that there's one idiosyncratic test result in there, and the defense attorney is then the one that asks you about it when you're in trial. Like, well, this is a weird result, isn't it? Wouldn't that be something that you would expect from an animal that was not neglected? And then all of a sudden you look like you're making the whole thing up, even when the entire weight of the evidence points to a certain diagnosis. Which is evidence, and which is lunch. This is another bad situation. Don't find yourself in this situation. I want to talk just for a minute about testifying, and then I can open it up to questions. My golden rule on testimony is this. Does it spin? Yeah. Tell the truth. underlined many times. The reason I say this is because someday you may find yourself testifying in an animal cruelty case, and one of the questions that you may be asked is, have you ever attended any trainings on animal cruelty laws? And you may, in my heart of hearts, remember that you attended this training, and they may take that opportunity as a defense attorney to say, oh, Mr. Kamens, he's an animal rights activist, right? Well, what did he tell you to say in this case? That's what I'm telling you to say. Tell the truth. That is important, even if the answer to your question, if you think it hurts the state's case, if you think it hurts your position, if you think it's contradictory, tell the truth. As a prosecutor, we get the privilege of representing the state, and what comes along with that is, we have to wear the white hat. So we have to be upfront about everything that we have in our possession. So tell the truth. Please tell the truth. Now, when people get on the stand, it's a weird situation. It's not like normal human interaction at all. It is different than anything that you will have experienced in your life. And so a lot of times you may not understand that you can answer truthfully, but still respond to the questions in a way that sort of makes sure that you're telling the whole truth, which is the other part of telling the truth. If a person asks you a question, if either lawyer from either side asks you a question and you don't know the answer to it, the answer is, I don't know. I don't know. Because that's the truth. If they ask you a question and you did know the answer to it, but you don't remember, then the answer is, I don't remember. And if they ask you a question that to your mind sounds like gobbledygook, or you stop following it after the third phrase in the question, the answer may be, could you repeat or rephrase the question? The reason I mention those three specific situations is because if you get yourself into a circumstance where you're on the stand and you're answering a question that you don't know, you don't remember, or you don't understand the question, and you try to answer it anyway, you look like you're lying, right? And you don't want to look like you're lying, and you definitely don't want to be lying. So be sure that you understand what it is you're answering before you answer it. You can always say, I don't understand, what you're asking me. The other thing to keep in mind is that, these sort of tricky questions, or these questions that you may not know the answer to, or questions that you may feel like, oh, this is going to really screw up the state's case, are going to come from defense attorneys, because that's their job. They are there to try to create doubt about the certainty of your testimony. And what you have to remember is, when you are testifying on behalf of the state asks you the first set of questions, then the defense attorney gets to ask you questions, then the state gets to ask you questions again. So if there's anything that's unclear or contradictory or concerning about your answers to the defense attorney's questions, the state can always come back and say, when you answered yes to this question, explain a little bit more about what you meant by that. Tell the jury why that may not tell the whole story here, or ask further clarifying questions to illustrate. And I say that both to, reinforce that tell the truth is the bottom line, and to encourage you not to be combative with defense attorneys. Because when defense attorneys are cross-examining you, another thing that will make you look like a liar, make you look bad, is if you're taking offense and you're getting snippy and you're getting annoyed and you're visibly shaken by their presentation. So, good things to know about your cases before you're going in is, what is this hearing that I'm testifying at? Because it's not always going to be a trial. Like we talked about, there are pretrial forfeiture hearings. There may be motions to suppress. There may be other kinds of hearings that the judge is going to want to hear from you. So make sure that you know from your prosecutor, what am I here for? What is our ultimate goal in the hearing? You want to know maybe if it's a misdemeanor or a felony case. That's not going to change anything but the number of jurors that you have, but it's, it's important to be aware of what your case is. Is this a jury trial? If it's a jury trial, that means that you're going to be testifying to either 6 or 12 people seated in a jury box. And you should be directing your answers to them. This is another thing that's weird about testimony, is that somebody's going to be asking you questions, and you're going to be directing the answers to somebody else. If it's a bench trial, that means that the judge is making the ultimate determination. So instead of talking to a jury, you'll be talking straight to the judge. Public defender or retained attorney, that is not something that makes any difference, but it is something that may be a variable in your court hearing. I have seen public defenders who have done A+ work, and I've seen retained attorneys that have done C- work. I've never seen an F appearance before, but I've seen good and bad on both sides of the spectrum. I already talked about this. It's good to know your case, as much information as you can, because when you turned in your reports or when you saw the animals, the case was in one procedural posture. When you're in trial, the case is in another procedural posture. There's been an information or an indictment filed by a prosecuting attorney, and this is the parameters of the case. This is what you're going to be testifying about. This is what you're going to be asked about. If you get an opportunity, I actually had this presentation ready for a different group, or this slide, I guess I should say, ready for a different group, to point out all the different parts of this document that you may have never considered before. So if you get an opportunity, check in with your prosecuting attorney about, well, what is this case actually about now? Now that we're here in court, what are all the things that we are trying to prove? It's good to know if there have been any motions litigated in the case. Very often those motions can come right before trial. A defense attorney will say, Judge, I have a motion where I don't think the state should be allowed to testify should be allowed to present evidence about this, this, and this. And the judge will hear argument on it, and they'll make a decision, and that could happen right before a jury is brought in. And if your testimony has to do with those issues, you want to know, because the last thing that you want to do is be testifying about something and just start talking about something that the judge has already said cannot be mentioned. So check in with your prosecutor. Has anything been excluded? What exhibits are you going to be testifying about? Is the prosecutor going to be handing you pictures during your testimony and saying, can you identify this picture? Can you identify this picture? Because if they do, and you can't, that could be a problem. If it was a picture that was taken by somebody else, sometimes you can still testify to it. You just have to be able to identify it. So you can say, oh yes, this is a picture that was taken that shows a true representation of this sheep on the day of the seizure. Does the defense team have an expert witness? This is more geared towards veterinarians, but it could be anybody involved in animal welfare work. If the defense has an expert that's going to be coming in to rebut any part of the state's case, very often the state's expert will be allowed to remain in the court to listen to that testimony. Usually witnesses are excluded from court during trial, but one of the things that you may want to do is come back and testify again, saying everything that the defense expert said is questionable because of X, Y, and Z. So you may be asked to stick around and listen to what that person has to say. Okay, any questions about testimony or testifying or really anything, because that is the end of my slides. I think I have about 10 minutes left, so I'd be happy to talk.
Open range.
Yeah.
You know, a lot of open range around here.
Yes.
Recently we had 3 horses that were running loose on open range for 3 months.
Yeah.
And I've always been told by the brand inspector that no, we can't go pick them up even if they're running loose, and do you suppose that they've been turned loose by the owners? So what would
Well, it's tough, right? If it's somebody's animal, right, presumably, and they are letting it out on the open range just because they don't want to have to give it care. Are they abandoning the animal, or are they intending to take it back? Okay. Well, if that's something you can establish in some way, I would say, you know, and obviously any of my comments have to be construed as sort of hypotheticals in the air and not specific. But if that's something that you could establish, that somebody had relinquished ownership, it seems like some agency or organization would be able to take control of the animals, but there's probably a lot. Yeah, go ahead.
So you would want to go to county council and talk to them, but that person, in order to run open range, has to have a grazing permit.
But I'm just talking about somebody that lives next to 140, and they literally move and they turn their livestock loose. Their horses.
They turn their horses loose on the one.
They just turn them loose and the horses go wherever they want to go.
Okay, but they don't have an open range grazing permit. So it doesn't grazing permit. So a rancher will have a grazing permit for X number of cattle, and he can run his horses with them if he wants to, and some of them do off and on. But if they don't have a grazing permit, they just abandon them. And, you know, unless, you know, they have some agreement with some neighbor that we don't know about, but I doubt that. So that's what I would do, is just check that. You should be able to check whoever the person's name is. Call PLM or call U.S. Forest Service, the both of them give out grazing permits.
And there's usually the grazing permits for a certain amount.
Yeah,
Certain
exactly, yeah. And so then they can do whatever with that.
See, we don't know the name of these people. It's a given. The animals.
Are they a danger? Are they running
Well,
across?
yeah,
Wrong party? Because horses are
This
running.
one's out by baby.
Yeah, we got those. Yeah.
Yeah, we should, I mean, because that becomes a different issue then. Now you have public safety issues
Right.
on one point.
That's,
And abandoned property, so I would say creating risk, recklessly endangering, and we should be able to see some from that front too. Because you're probably, I mean, it's been a nice wet year, so they probably have enough feed right now. But they, you know, they're not going to shortly by the way the weather's going. So, but yeah, that's what I would do if I were you. Just check that out, and then these guys could probably help you with that.
Now, is that talking about those horses out there about Mount Market 38?
35, yeah.
Well, 35 is right there at Graceville.
Right.
And then 38's towards Babyport.
Yeah.
A lot of those horses have been there for years. They were Junior Anderson's horses when he was in Beatty and Bly country, and they're just holdovers from his wild herd pit.
That's the ones we got.
Wild herd that got turned loose.
Years ago, but these three have been just the last 3 months.
All right.
It's
Yeah.
2 buckskins, a little.
What about the ones up on Tablelands? About 40 head up there.
Those have been up there for 10 years that I know.
You're just like, whatever, it's not mine.
40 head up there.
Although we should think of it as a fundraising thing, because we can get some of those Tiger Mustangs. Like I saw one running.
There is some up there.
Oh my goodness, that are tiny black stallion, and I was like, you could get him, you could make a lot of money.
Right there at Wild Billy Lake.
We can spend a lot. If you try to find that person, you notify one paper, because we had this one, we had a horse for almost 3 years.
Yeah.
They said they couldn't,
Yeah.
they told the owner, the owner would be, so they wouldn't.
Well, and they knew who the owner was?
Yeah.
Yeah, and you know, the forfeiture, pretrial forfeiture statute depends on a criminal case being pending.
Right.
So if there is a criminal case pending, then there's no reason why the DA or the agency itself couldn't bring that pretrial forfeiture. For agencies that, if there's some reason that the DA wasn't doing it, you know, the agency may have to retain legal counsel to do it, but there's no reason why it can't happen.
And we're having that discussion, just so you guys know right now, because we've had so many changes in leadership, I guess would be the way to put it out of the DA's office. There used to be an old policy, and it used to be the county council handled it, and then it got dropped, and I guess at some point, I don't know if it was Patrick or somebody said, oh yeah, we'll do it, then the AG got appointed, and they said, no, we're not. And so it's just been a whole, and it's an expenditure of money and resources. And so you have an appreciation of what we deal with here.
Yeah.
Since I've been appointed, we've had 3 homicides.
Yeah.
So, you know, that's where, so we have to figure out what then, so that's a contract that the county can pay us for, but I'm not sure that they've been paying us for that, so we've got to make that clear. And if they are willing to pick up the foot bill for it, we'll do it. So if not, then I guess county council is going to do it. So, or you can do forfeiture procedures.
Yeah,
That's
yeah.
great.
Yeah, let me know.
So, but the one thing I wanted to mention, I've got to run for a judge's meeting here shortly. A couple of the things, weights are huge for us, weighing the animal.
Yeah.
And I don't know how much that's done here, but it really makes a difference. Okay, weigh them when we get them and weigh them right before trial, so that we can show the difference that's associated.
With horse with a weight tape, right?
Huh?
With horses, like, can we use a weight tape?
Yeah, you can use a weight
You
tape.
can use a weight tape, it's better to have numbers here, I think. And we've got enough people that are rural, that are familiar with animals and livestock, that I think it's probably harder to prove these cases here
Yeah.
than anywhere over on the west side.
That's probably true.
So that would be important. The other thing that he said about photographs are crucial in keeping them aligned with stuff. And then the other thing, just having, been a defense attorney for a long time, you guys lose control on the stand and I walk. I walk through that open door and I win. And I used to a lot. And you can't do that. One of the things that we learned as defense attorneys is you are not Big Brother. It is not your right to get up there and rage and argue and do that stuff. You do that, you take it away from the jury. You want the jury to get to be angry. You want the jury to get to feel like they're the ones that are being a hero. Every story has a hero. You guys are not it. You're a puzzle piece that's helping prove the story, provide a story. But when you start to lose control on the stand, show passion, get indignant, start calling names, as if you have a good defense attorney, I'm going to walk that all over the place. And this applies not just in animal cases, it applies in every single case.
Yeah.
And one of the things that I've noticed about the best attorneys on both sides, and Kirsten Snowden was a prosecutor in Multnomah County, who I'm friends with from law school, and we both went to similar trainings, is it's not about you. If you need to rage, go get it done before you get on that stand. And then it is cold, hard, calculated facts. People nowadays, when they come in, they expect CSI. They expect logic and reason. And they want to be the ones who get to rage and who get to do something to bring justice. And if you take that away from them, and it's both sides of the fence, it doesn't matter. I used to lecture all of my witnesses when I was a defense attorney about that. It's not about you. It's really got to be about the jurors. So that's the one skill set, and it's working across the nation, because when I did capital cases, I went to nationwide trainings. The best of the best of the best are telling us, and these are guys that win cases non-stop. Do not let your witnesses pontificate, rage on the stand, because it takes away what the jury wants to do. So that'll be the only thing. And I'll remind you about that. And if we get to a trial, we'll go through all of this. I'll have gone through everything with you. You'll know what the case is. You'll know what we're trying to do. And I will always, always, always say tell the truth. Good, bad, or indifferent. Tell the truth. Another fodder for a defense attorney. I mean, really seriously. And I had a great case here years ago, and unfortunately, no hard feelings, you guys will understand. There was a couple of young law enforcement officers from here that kept trying to cover up something, and they did it. Then CHP's involved, there's California Highway Patrol, they get up there. I asked the same question. No, ma'am, didn't do that. Yes, ma'am, should have done that. Don't. Takes it away, right? That's all you have to do. It's fine. You say, no, I didn't take good enough pictures. Yeah, I understand that's hard. Just, it's hard not to do that because you get passionate about cases, everybody does, but you just have to remember, trust the jury system. There's a reason that 95% of cases should be won by the prosecutor. And that's because we make the right decision about who we charge in the first place, and then we make the right decision about how we present our case. And so, that's just, but if you guys have questions, feel free to call me. I have, pass out the cards for those. You guys already have. Cards that I don't have.
I have cards too.
Cards, and if you guys have questions from me too,
to pick you?
Yeah, so if the way that I get involved in cases is if it's a resource issue or a complex case or, like she was saying, the pretrial forfeiture issue, they may call me in on a certain type of case or kind of case. So, and I've done work here.
Pick that back up.
Yeah.
Because I was surprised that they haven't been Curry County, because that creates a legal issue for law enforcement too at some point.
Yeah. Well, thank you. Thank you for coming up.
Who are we looking at here? If we have a case and we've brought in deputies and they have done their research and built their case, who gets the warrant? We go to you? Okay.
Yeah.
You,
She may call me. She may call me in
I
depending
may call,
on
but
how she
I'll
wants.
tell you,
But
it's
DOJ
her
is
job to call
yeah.
you. That's all we want to know.
Yep, so just give us a call or an email, all right?
Hey, Dave, we did an awesome job in Curry County because
I appreciate that. That was a tricky case.
Jack really had a lot of guts to go out there and photograph where those dogs were. And
Yeah. Yep. Any other questions? Yeah.
Just for clarification, and Deputy Borges and I discussed this a little earlier before you came in. I have run across this a couple of times in the last few years. Originally, we were taught by a prior district attorney that as agents for large animal investigators for the Humane Society here,
Yeah.
we could go through a latched gate but not locked, drive or walk up to the door to knock on the door, try and raise a human. We could not collect evidence along the way.
Yeah.
After we made contact with someone over 18 that owned the horses, if that's what we're looking at, and we got their permission to look at the animals, then we start collecting evidence.
Okay.
And then we're okay, we're not being charged with trespass, and that person can't come back and gripe about that. This is what we were initially.
Yes. So you guys need to have some kind of multidisciplinary team meeting. I'm looking back there so that there's clarity on that issue. Because I don't want you to, I certainly am not going to tell you legally, I'm not going to give you any legal advice because I don't know what the policies and procedures are out here. What I would say is the only animal welfare organization that I'm super comfortable with just going to a location and starting an investigation is the Humane Society because they have sworn police officers. You know, they have DPSST trained officers who know the laws and the issues with getting it, and they can get a warrant if they need to. I don't know what the relationship is between your agency and the sheriff's office and the DA's office. So I would strongly urge you to figure out a way to put a policy in writing about that if possible. And then I know this always runs into a resource issue, but my main recommendation, not legal advice again, is that you have a law enforcement agent with you when you're doing that kind of thing.
In the past, what we've done is we will go out and we will do our investigation, pictures, review our report, email it to the deputy who we want to go out because we have a select number of deputies who are educated in large animals.
Right.
And then they would go out, they would do their investigation, shoot all the paperwork off to the particular DDA that we had in town. And we were all good. We all knew the way it was going to go. No misunderstandings.
Yeah, it's no
We've gotten away from that. That's why I'm asking for clarity.
Right, and the problem is that it's not a problem until it is a problem.
Right.
You know, it's not a problem until one defendant says, hey, wait a minute, you guys are state actors, and I did not give you permission, or you did something incorrectly, X, Y, Z. So I really encourage, you know, how child care advocates very often work in multidisciplinary teams where they have a district attorney, a member of law enforcement, a DHS person, social workers, and everybody sort of sits in the meeting together and they decide how they're going to work on these cases all together, and they set up policies and procedures and they follow them. You know, that's what I would encourage in animal-related cases as well. I'm not going to give you any advice. You can do your work, but be careful. Thank you. All right, and be safe out there. Thank you.
very informative.